Josh Ritter. And Josh, I was just watching the expressions on the defendant as she's sitting there and her facial expressions, in addition to the zealous representation and arguments being made. And I think the reality is we know that there are facts that are contested in this case. We know that she's saying the cops inside the house at the party did this and it's a huge cover up. And so there's I think there's going to be a real battle. But in this case, as you watch them get ready for that battle, are they going to are they really going to put the police force on trial, so to speak, and say these are bad cops and they did it?
It sure sounds like it. I mean, they're really on the offensive here. Usually you do not hear the defense kind of showing their theory of the case so early on, but it sounds like it was important, at least for this evidentiary hearing or discovery hearing, what they were having here today. But yeah, we got a sneak preview of what they're going to argue, and it sounds like they intend to be really flipping this courtroom around and putting the police on trial here as much as they can. And it sounds like that will be their tactic, to take the offensive rather than the defensive in this case.
Yeah, and taking the offensive, Josh, what you heard there in the arguments, they're asking for a lot of different documents, a lot of different discovery. I just want you to educate our viewers. And there was some suggestion that the prosecution is saying this is a fishing expedition. Defense attorneys, you want to get as much information as you can, but you're not allowed to just go on a quote-unquote fishing expedition. There has to be some nexus or connection to what you're asking for instance, dog records, to the case, and it has to be just more than just a tenuous connection, correct?
Absolutely. The prosecution is under the obligation to turn over everything that they have in discovery. But that doesn't mean that they somehow need to do the bidding of the defense. And if the defense wants a whole bunch of other records and things that the prosecution feels that it's not necessary to their investigation or wasn't somehow important to their investigation, they don't have to start going about, on these random goose chases for the defense. And so it sounds like what this hearing here is them trying to convince a judge that no, this isn't us just fishing. This isn't us just casting a very wide net, but we have very specific reasons that we've articulated to the court of why we believe that the prosecution needs to turn this stuff over. And if that's in the custody of the prosecution, it sounds like the judge might compel them to do so.
Well, that's what I wanted to say. Let's follow up with that little legal piece thread, because if the prosecution has evidence, they don't get to pick and choose what they're going to provide to the defense. They have to provide all of it, and whether it's exculpatory or not. And so I'm a little troubled if the prosecution has it that they don't have to produce it. I do understand if the prosecution doesn't have to have it, well, they don't have to go get it. The defense has to subpoena it. But Josh, are there any grounds? Are there any grounds for a prosecution to keep that in the last 30 seconds and not have to give it over?
No, there is not. I am not entirely familiar with what the rules are in Massachusetts, but I will tell you that the prosecution, though they are stewards of the evidence, you're absolutely right to point out, Ashley, that they are not the ones who get to decide what is important for the defense to see and not. The defense needs to see everything in order for them to form their own theory of the case. That shouldn't be something that is decided on their behalf by the prosecution.
Right, absolutely agree with you. All right, there is so much to talk about today. Unfortunately, we're out of time. Josh Ritter, thank you so much for joining us. We could talk all day about all of this. Your show's coming up. What